All right. The Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. Good morning, and I want to welcome everyone to the 10th Court of Appeals sitting in Waco. We have 3 cases on our morning docket, 2 of which will be called now at the 9 o'clock hour. The third one is set for 11 o'clock. And so when I call the case, I would like the announcement of counsel if you're ready or not. And if you're not, then we've got a problem, but we'll deal with that. If there are any preliminary matters that we need to resolve, exhibits you're going to try to use or anything, we need to know that at the time that you make announcement. And if there are, I need to know who's going to be making the arguments. It looks like it's going to be pretty easy on this side, but since we've got a couple of counsel over here, I need to know that. I will call both cases, so the second case will also be called. And this is the time that if you have a cell phone, make sure it's in the off or silent position so that doesn't interrupt the court. Also, we do let folks move around during the oral argument. If you choose to do that, be sure you do it quietly so that it does not interrupt the flow of the proceedings. And with that, first case on the docket today is Pena versus Nexion.
Good morning, Dawn Smith on behalf of the appellant, and I'll be arguing today.
Okay, thank you, counsel. Who is your co-counsel, if I may ask?
Jacob Runyon, Your Honor.
Jacob
Runyon, R-U-N-Y-O-N.
Yes, okay, thank you.
And Your Honor, for the appellee, Alex Bell for Nexion Health at Waxahachie.
Welcome back to McLennan County, Mr. Bell, and believe it or not, you do not appear on our docket sheet as a counsel of record. You will need to remedy that before you leave today with the young lady that was sitting over there in the clerk's office. Make sure you have a notice of appearance.
Yes, Your Honor, I believe I filed one several days ago, not last week.
Okay, well, the docket, my docket sheet was printed when we set the case for argument, so your presence wasn't noted at that time. So
Thank you, Your Honor.
any objection to proceeding with Mr. Bell on case?
Well, of course, no.
All right. Be a cheap win for a little while. All right, next case is Rodriguez versus State.
Yes, good morning, Your Honor. John Gilmore and Aaron Diaz, behalf of Arnold Rodriguez. I'll be arguing this one.
Good, thank you, counsel.
Sterling Harmon for the state. I will be presenting the argument. In regard to the presentation of the argument, had a brief conversation with opposing counsel earlier. We believe we're going going to limit our argument to the first 3 points of error regarding sufficiency and double jeopardy claims, if that's.
That is correct, Your Honor.
But I'm assuming you're not waiving any other arguments you made in briefs.
We are not.
Okay. Thank
Nor
you,
is the
Counsel.
state. And of course, if y'all want to talk about it, we're gonna talk about it.
Yes, that is the nature of the way things work. So,
Thank you, Judge.
thank you. And Counsel Smith, you may approach the lectern when you're ready. The time as announced is 20 minutes. Each side, 5 minutes for rebuttal. And
Justice Gray, may I reserve a little more time for rebuttal?
we don't do that.
Don't do that?
It's 20 minutes on the front end and 5 minutes for rebuttal. So
Fair
thank you,
enough.
Counsel.
Yeah.
You may proceed when ready.
Thank you. Good morning, Justice Johnson, Justice Gray, Justice Smith. My name's Dawn Smith, and I represent Martha Penna in this matter. There are really two issues before you today. First, whether Martha Penna had the proper standing to bring this lawsuit for her mother for injuries and damages associated with nursing home abuse and neglect by Nexion Waxahachie. The second issue is whether or not she had capacity to bring suit or whether or not that capacity issue was addressed by the relation back doctrine because of her petition to be appointed as administrator of the estate while this matter was pending. First of all, I think the framework of this case is dictated by Chapter 74, medical malpractice case, which I think deserves a little bit extra attention in this particular matter. The Lovato case is very instructive. It's a Supreme Court case, 2005. I'm excited to that. That court or that case did not really bring up the issues of Chapter 74, but it's important here because we didn't name the estate in our pleading. Under Chapter 74, Section 74.0014, make sure I got that right. 0012. There is only one claim. One claim, regardless of how many claimants there are, under the statutory framework that the legislature has set up, there's only one claim in this particular case. So Martha Penna was the daughter and proper heir of her mother, Miss Ontiveros. She had immediately upon her mother's death had derivative standing to file this suit. I think it's also important to note that we had to file a notice of claim in this case. Our notice of claim put the defendant on notice as to what claims and causes of action would be pursued. And that notice of claim is at the record or in the record at page 314 through 315. Those notice of claims were served on the defendant in April of 2015. That was before Miss Ontiveros had passed away. So these claims really originated while Miss Ontiveros was still alive. We did file suit as Martha Penna on behalf of Miss Ontiveros, her mother. So that's really where kind of the issue comes up and where counsel for the appellee argues that Armand is instructive to this court. So the differences, and just to kind of cut to the chase on the differences in that case, really are that a deceased person certainly cannot file a lawsuit. We know that. In this particular case, a deceased person did not file a lawsuit. Her daughter filed a lawsuit. Her claims were preserved and she had standing immediately upon her mother's death to bring those claims. So in this particular case, there should be no issue as to standing. In the Armand's case, which relied on Covington is 179 Southwest 3rd, 583 at page 585. Armand's relies heavily on Covington. In that case, the person that brought the lawsuit actually didn't have any capacity as an heir. No derivative capacity or no derivative standing whatsoever. The survival statute is very clear in that a decedent's action, and this is a decedent's action survives his death, and it is derivative of the decedent's rights. So I like to think of it in this particular way. So if Ms. Ontiveros had a cause of action and that survived her death, then it was always viable. It's almost like Ms. Ontiveros passed away and then the claim survived. So it was always intact. Immediately upon Ms. Ontiveros' death, that claim passed to her daughter, Martha Penna. So immediately, and at the time that Ms. Penna filed the lawsuit, she had standing to bring that claim. It was her claim immediately. So unless there are questions as to the standing issue, I'll move on to capacity. I think Lovato makes it very clear that the relation back doctrine applies. So under Civil Procedure 63, we had up until 7 days before trial to file a suggestion of death. And as long as we pursued an administrative capacity, right, a representative capacity with probate court, then it filed that timely before the claims were resolved, then her capacity issue related back to the claims. There are absolutely no new causes of action in this case. The defendant cannot claim in any way that it was surprised. So for example, in Armin's, that was a premises liability case that has no procedural requirements like that under Chapter 74. So Chapter 74 is specific. We have to file a notice of claim. So they knew about the claims as early as April of 2015. And those claims have never changed, not one time over all these years. Now we're in 2020. So when these claims, the defendant was put on notice, then we also had to file a Chapter 74 report, right? Where we have an expert.
Somebody correct me if I'm wrong, but I thought we were in 2022,
What did I say?
2020.
I've lost 2 years because of COVID. No,
Okay.
we are, you're right. I was just talking to Mr. Runyon about that today. I really feel like I've lost 2 years.
All right, now, let me interrupt you just a bit on the, so the claim was made while she was alive.
Correct.
When the suit was filed, the Chapter 74 notice was provided. And how much do we need on the standing question? Do we need to dig into the personal representative issue and how that was developed and the timing of that?
I think if I understand your question, the personal, so if we would have filed this lawsuit, Martha Penna, as representative of the estate of Ms. Ontiveros, there would be absolutely no question we wouldn't need to be here. So because the complaint is very clear that it's for past damages, there's no future damages alleged. Am I hitting the point of your question? I don't think.
Yeah, I'm going to argue with you a bit there,
Okay.
but go ahead with your question.
So
Right.
instead of, I mean, this is a prime example of an issue where everything is perfect, not perfect, the petition could be much better, but everything is perfectly laid out, and there would absolutely be no question if we added 3 more words to the caption. And the issue there is the claims are exactly the same. Defendant had notice of all these claims. There is no potential to have additional claims because of the framework of Chapter 74. So that's the standing issue, right? Who had standing to bring this claim? Certainly the estate had standing to bring this claim. And like I said, we wouldn't even be arguing about this if we would have named the estate. But
But at that time, the estate as an entity did not exist.
well, an estate automatically exists, Your Honor. I actually researched that a little bit this morning. The estate had not been set up yet, right? We hadn't filed our petition with the probate court, but immediately upon death, there are certain assets, personal and otherwise, that passes to a deceased estate. So the formal proceeding, the formal probate proceeding, which has been completed at this point and which was initiated before the judge made his ruling in this particular case. That is more of a procedural issue that the Supreme Court has already said relates back to the filing of the lawsuit. So I think really the hard question here is the standing issue, right? If the estate automatically had standing and we didn't name the estate, we named Miss Penna, then did Miss Penna have standing, right? Was she the injured party that had an issue that needed to be resolved by the courts? Did she have standing when we filed this lawsuit? And in this case, she did, because the lawsuit, the claims, they never died. They immediately passed to her. You don't have to go and set up a formal probate proceeding for that to happen. The survival statute that was enacted in 1885 or something like that creates an immediate transfer of the rights of the decedent to the right of an heir.
How many errors were there?
Well, there are a lot of errors in this case. I think there are 8 errors. But there's no wrongful death claim in this case.
Was there a will?
There was not a will. There is a dependent administration that has been set up and letters of administration issued at this point. So there was not a
Miss
will.
Penna is the PR.
Correct. Yes, she is. So we have correct the procedural deficiencies, which is the capacity issue. All of those issues have been corrected. And I think
What was the timing of the informing the trial judge that the Miss Penna had been determined to be the personal representative of the estate?
that happened just a few days before the first summary judgment hearing. So the probate petition was filed on February 13th, I believe. And the hearing, I have it here. February 16th, 2018. And then the first hearing on defendant's motion for summary judgment was on February 23rd, 2018. So, and I certainly had been before the court and argued a Chapter 74, the Chapter 74 report, and I made an error during that proceeding because we had initially initiated the claim, the lawsuit, by filing a notice of claim when our decedent, our client at that point, was still alive. So at that point, when I was arguing the Chapter 74 report, I was completely misinformed and I should have been better informed that she had passed away. And I told the court that I believed that she was still alive. And we corrected that issue and we initiated probate before the court made any kind of ruling as to capacity or standing in response to the motion for summary judgment that was filed by.
As I recall the facts, the representation in the hearing was that she was deceased. And then somebody attempted to correct that and say she was alive, and then in fact corrected that correction to report that she was deceased.
That's right.
Does any of that matter to the standing question?
It doesn't. It does not. Because the only issue to really look at is it's not a notice issue. It's not a notice issue because there's only one claim, right? The defendant was on notice in April of 2015. Then on notice again when we filed our Chapter 74 report and presented expert testimony on the issue. So the representations that were made have nothing to do with whether or not Ms. Penna had standing, right? She either did or she didn't.
Okay, let's talk about what the trial judge did. Did he dismiss the case? In effect, saying there was no standing, or did he get to the capacity question in the judgment?
In the judgment, and I am not positive, I have not reviewed that judgment this morning, but it's my understanding that it was a standing issue that he decided on, not a capacity issue. He did not allow us to amend our petition. So we had moved to amend our petition to include the correct pleading, the correct title of the lawsuit to be Martha Penna as representative of the estate.
You had made that motion. Did he rule on that motion?
He did not rule on that motion.
Okay.
He did not deny that motion. He did not rule.
Which is what would have happened in the event that he addressed the standing question.
Exactly.
Okay. The part I want to hear your response to is that in looking, because I'm sure that Counselor Bell is gonna raise this in your original petition that was on file at the time of the standing question being decided by the court. When you get to paragraphs 20, 21, it's basically in the section E under medical negligence, the attributes, I guess I would say, the nouns and pronouns of the pleading seem to shift. That the plaintiff is referred to as Miss Ontiveros, notwithstanding that earlier in the pleading, there was also a Miss Holly and a Renfro address reference that was probably from a form that was being used. But earlier in the pleadings, it talked about plaintiffs and defines plaintiff at the beginning as Martha Penna. How do you address the issue that there in the medical damages section, you seem to revert back to the plaintiff as Miss Ontiveros?
That is a good question, Justice Gray. So I would say, and I'll address your issue, but I would say it really doesn't matter in the grand scheme of things. It doesn't. This is a notice pleading state. We put the defendant on notice that Ms. Ontiveros was injured at their facility. We went into detail about how she was injured and how they reached the standard of care. And that claim immediately passed to Martha Penna. Now, if we would have filed this lawsuit, and I'm not sure if ARMS actually got this issue right, but if we were to have filed this lawsuit just as Ms. Ontiveros, then I think that ARMS would be a little bit more troubling. But because a dead person doesn't have standing, right? But she's not the one that brought this lawsuit. It's her daughter that brought the lawsuit. So she has always had standing.
I've got to ask this, and it seems hyper technical, but if the daughter brought the lawsuit, who provided the pre-suit notice? And does that matter?
If the daughter, so the pre-suit notice, Ms. Ontiveros was still alive, right?
That's the point.
Yeah, that's your point. So if, so then in that particular case, if we were completely.
Let me see if I can collapse the question. First, to my previous, it sounds like the short answer is bad drafting doesn't matter.
Bad drafting doesn't matter.
Okay.
That's right.
Now, with regard to the notice, do we have a notice and does it matter with regard to the suit, or is that a claim notice, not a party notice?
Well, it's a claim notice. If we would have gone forward and given that notice as a claim and then not had Martha Penna in the lawsuit, then I think we would have been in serious trouble. Because we switched from.
I mean, I'm frankly surprised that I haven't seen this happen more often, where the claim is noticed by a person that has been injured and then dies, and then the suit's brought. So maybe it's not an issue at all, but.
It's the first time it's happened to me, for sure. So, and really, I didn't even, yes, just.
It isn't the purpose of the notice pleading, or the notice that you send, is to tell who did what to who,
Correct.
not necessarily who's going to sue you, but who did what to who.
That's right.
Okay.
And that's what chapter 74 requires, right? I mean, there's so many hurdles and pitfalls associated with chapter 74 for sure. But I think that it's a very, the pleadings for the law, I guess I should say, have really been kind of broadened to where we as plaintiffs lawyers have a good understanding of what we need to do to make sure that we're protecting these claims. Initially, it was really difficult, but now there's quite a bit of case law that tells us how to handle these type of issues. But I think that when we're talking about chapter 74, the fact that there's one claim, right? Just one claim, that kind of resolves the issue of standing. So if she would have died because of what the defendants did to her and there was a wrongful death claim too, then I can understand why there might be some sort of confusion. But we never allege wrongful death. We only allege that the defendants were negligent and caused injury to the decedent. She was alive when we did the notice, and then she passed away during that notice period, and then we filed a lawsuit as Martha Penna on behalf of Ms. Ontiveros, and Ms. Penna had standing. So with that, unless there are additional questions. Right, Ms. Penna had standing when the lawsuit was filed, and we corrected the issue of capacity during the lawsuit and before any ruling by the court on the motion for summary judgment. And that related back to the original filing. And with that, we would ask that the lower court's ruling be overturned so this matter may proceed. And
Thank you, counsel.
thank you.
You'll have 5 minutes for rebuttal. Next, John, you may proceed when ready.
Thank you, Your Honor. So there, as I see this case, there are two procedural issues. The first is this court's jurisdiction, which was not addressed by the appellant. We have raised in our brief an issue with the timing of the motion for new trial and the notice of appeal. So in this case, Your Honor, the memorandum opinion that actually grants the summary judgment was dated October 10th, 2018. And so this is a memorandum order that grants a summary judgment motion. It's filed with the clerk and served on the parties. And that memorandum order constituted a final order under the Texas Supreme Court precedent.
Did it contemplate further action on your client's part?
It did, Your Honor. It contemplated an additional order being submitted.
And what do you think that order was going to be?
Your Honor, it just said a formal order reflecting the court's ruling. And so the language that I think is important from the Lehman case that we cite in our brief is that an order can be a final judgment for appeal purposes, even though it does not purport to be if it actually disposes of all claims pending in the case. And as plaintiff's counsel indicated, the only claim, there's one medical negligence case, and the memorandum opinion clearly indicated that the judge was granting the defendant's summary judgment motion on that one claim, which disposed of all claims in all parties. And so even though it contemplated the filing of an additional order, that additional order didn't change the relief granted in the original motion. And so that original memorandum order constitutes the final judgment under the Supreme Court's precedent. And so I understand this may seem like a trap for the unwary, but I think Lehman recognizes that final judgment language in a particular case can be a trap for the unwary, just because even if a judge doesn't understand that what they're doing by granting a particular order, if it has the effect of resolving all issues and all claims as to all parties, then it is a final judgment, whether it says so or not.
But just to be clear, the trial court didn't intend it to be a final order.
It does not appear so, Your Honor. It specifically asks the defendants to submit an additional order, which was submitted and I believe signed in November.
Okay. And the appeal is timely if it's measured from that date.
Correct, Your Honor.
Okay.
And so moving to the issues that the court was addressing with appellant's counsel, I believe the pleading is incredibly important in this case, Your Honor. It's in page 9 of the record, and this has to be looked at from the posture of which defense counsel would have understood the notice of pleading. And by that I mean, so from what I understand, the original notice claim, the Chapter 74 notice, is not in the record. So we don't have the details of exactly what that notice of claim said, what the parties were, whether it indicated there had been a death or not. So we don't have that to rely on. What we have is plaintiff's original petition. Our plaintiff's original petition, as you have noted, is a mess, for lack of a better term. It refers to Ms. Pena as an individual in the party section. It sometimes goes from plaintiff singular to plaintiffs plural. There is a reference to someone who's not involved in the case at all, Ms. Faustine Hawley. And then it goes through at various times, as you note, and indicates that maybe it's Ms. Pena making claims in her individual capacity, because there's a reference to her being damaged individually, as if like she, the plaintiff, has her own damages as a result of Ms. Ontiveros' pain and suffering. That's on paragraph 17. Plaintiff suffered substantial injury and damages, including Ms. Ontiveros' pain and suffering.
So I'm sure if you were confused, your client immediately filed a special exception.
So when we found out about Ms. Ontiveros' death, that's exactly what happened, Your Honor. So the way this case is pled could reasonably be inferred. There's no mention of her death. There's no mention of a survival claim. There's no mention of her estate. There's no mention of Ms. Pena's capacity as an heir. And so by all appearances, this looks as if someone is suing, for example, as a next friend, or perhaps somebody who has a capacity as with a power of attorney. That's what it looks like. And the letter you referenced, Your Honor, added to that confusion because the September 6th letter, which is on page 125 of the record, indicates that Ms. Ontiveros is still alive. I believe the summary judgment evidence that's attached indicates that the first time the defendant actually found out that Ms. Ontiveros had passed was at Ms. Pena's deposition. And she was deceased as of July 10th of 2015, more than 5 months before the case was filed. And so if you look at the timeline, Your Honor, the disclosure of Ms. Ontiveros' death was in November of 2017. The defendant immediately filed an amended answer December 1st of 2017 with those very special exceptions. There was not an attempt to amend the pleading to fix any of that until a year and a half later in June of 2018. And so the issue, the pleadings had given every appearance that Ms. Ontiveros was still alive until we factually found out otherwise.
Were the special exceptions ever ruled on?
They were not, Your Honor. I believe there's a fair argument they were impliedly ruled on in the summary judgment motion because it ended up being granted. And so there's some language in there that the judge put in the memorandum opinion that specifically says everything in the defendant's arguments are what I'm deferring to in support of my ruling. And so the special exceptions were part of the summary judgment argument in that particular instance. And so in that context, the problem goes back to the original petition. There's no argument that Ms. Pena actually had standing in her own right to bring the lawsuit, right? She's not the one that was injured. She doesn't have individual standing. And so if she's suing on behalf of, let's assume she's trying to assume some kind of like next friend or lack of capacity or power of attorney standing. She doesn't have that standing at that point because Ms. Ontiveros was deceased. The deceased person no longer has that capacity to borrow so that she has standing for the injury. The estate is now the one that has
But
that.
she is in fact the daughter. It is in fact styled in her name.
Correct.
And so why is that not the required standing under Lovato?
Because under Lovato, in cases that interpret Lovato, the plaintiff had always pleaded that she was suing on behalf of the estate. The issue in Lovato and also Lawrence v. Dunn is that the pleading had always indicated, one, that it was a survival action, and two, that it was on behalf of the estate. What was lacking in those cases was the actual capacity. They hadn't filed the administration yet. And so what the courts had said in interpreting Lawrence and Austin and also Flores v. Cameron County, a Fifth Circuit case that cited, is that if you have pleaded it, you can cure the capacity issue later. So long as by the time of trial, you cure the capacity issue, if you pled that you have it, you can fix it. If you haven't pled that you have the capacity.
But that's a capacity question, not a standing question.
Correct, Your Honor. And so the problem is if you haven't pled that you're in error or you haven't invoked the survival statute, there was nothing to originally invoke the trial court's jurisdiction, right? Because as
But
pleaded,
you've got a person that is actually in error that ultimately is the personal representative. And they're the one that filed the petition and made the claim, not the dead person.
correct, Your Honor. But
I mean, which makes it really different than arms or ever you pronounce that. Where the only person ever mentioned in the petition was the deceased. And we all know that a dead person cannot bring the claim. And so why is this? Why do you think so strongly that it's controlled by arms?
because, Your Honor, what arms is clarifying is that you can cure the capacity if you pled it. So the pleading on its face does not plead the proper capacity. So you can cure a capacity issue after the fact that you pled the right capacity. So as the plea on the face of these pleadings, there's nothing to indicate that she is in error. There's nothing that indicates that she's doing on behalf of the estate or in that specific capacity. And so you can't go back and plead that after the fact, because adding the estate after the fact is in effect adding a new party. And I understand that's not the exact factual scenario of Arms, but the other cases that Arms, Lawrence, and Dunn refer to when they talk about what's necessary to plead a survival action is that you both have to plead and prove the elements of the deceased cause of action and the survival statute mechanism.
To
So,
prevail, you have to plead and prove it, but
yes,
we're talking about beginning a lawsuit, who's got standing and when. And we know that Miss Ontiveros did not have standing at the time that she passed away, but she's not the one that made the claim. And so someone else made the claim. Factually, they've proven their connection to the deceased and the claim. And now they're the personal representative. I'm having trouble, as you can tell, of why that is not adequate under Lovato.
well, Your Honor, it's not.
Given that it appears that the trial judge ruled only on the standing question and not on the capacity question, but I know that you probably disagree with that.
I do, Your Honor. I think the memorandum order indicates that it was granting the summary judgment motion and didn't specify the grounds, but did include some language indicating that it was adopting the defendant's arguments.
But would you agree that if he granted the standing ground, he didn't reach the capacity ground? There would be no need to. And so if he only addressed the capacity grounds, which I don't think is what the argument is, then we've got a different case because it's not a standing question anymore.
I'm going to answer it this way, Your Honor. I think he addressed both because I think at the trial court level, it's apparent from the first summary judgment to the second that there was some confusion about the distinction and the interplay between standing and capacity. And the courts in these several cases, Arms v. Lovato, Dunn, and several others indicate that there has actually been a little confusion in the law, which is why they go through and specifically call out what the difference is between standing and capacity in those cases. And so I think he did address both, if for no other reason than to make sure that his understanding reflected what those cases reflected. And so I do think he addressed both of those issues. But I think the issue is, Your Honor, in order for her to have the capacity as an heir, she has to plead and prove that an administration is not necessary. Because otherwise, in order to have the capacity, she has to be the administrator if an administration is necessary. And the actions taken to go get the administration and then go get the capacity that wasn't pleaded happen after limitations have run on the claim. And so without the heir ability to bring the survival action isn't available to her unless she pleads that the no administration is necessary component. Because
But
otherwise,
isn't that a pleading deficiency though, rather than an actual deficiency?
yes, Your Honor. And the problem with it though is that if you try to re-plead that too late, then you don't have anybody that actually has the standing for the estate until after that standing's been granted to her.
Let me ask a question out of context. I don't have it in front of me, but I think capacity is a verified defense, is it not?
It is, Your Honor.
Okay. Did you file one?
Yes, Your Honor.
Okay. When in the context of things did you file?
It was with the defendant's first amended answer, which was filed December 1st of 2017, which was about 2 weeks after the death was discovered during the deposition.
Okay. And at that point in time, since she had died, Ms. Pena was an heir
Correct, Your Honor.
and could bring the suit.
I believe she's allowed to bring the suit as an heir if she pleads that no administration is necessary, because otherwise, if an administration is necessary, the only person that can have the capacity is the personal representative of the estate.
Okay.
So that's the nuance there. So I understand that an heir can have the capacity in a default situation, but if it's an estate that requires an administration, The only person that has the capacity to bring the suit for the estate is the person who's eventually appointed as the administrator or the personal rep. And so,
And let me ask you this, in spite of I'll use the polite term, inartful pleading. Is there any doubt in your mind as to who the claim is being made for and for what purpose?
yes, Your Honor.
Okay. Reasonable minds can be.
I believe so, because from the pleading, it shifts back and forth between who has the actual claim, right? Because there's actually some pleaded language in here that indicates that this tenant is claiming she has her own damages. And so that's an issue that ultimately gets fleshed out of her deposition. And when it becomes clear that there's a confusion about that factually, about whether she has her own claims, whether she might have some other capacity like power of attorney, or in this case, it was a limited medical power of attorney that did not give her capacity to bring a suit while her mother was alive, then those issues are what give rise to, okay, now I need to go figure out who the actual plaintiff is and what they're doing. And in light of the special exceptions, plaintiff had notice of those for 1.5 years before they ever tried to amend their petition. They didn't even try to amend their petition immediately when they started the probate proceedings, which might arguably have been timely if you look at the extension that's available to somebody who's deceased under the statute of limitations, but even that ran in March of 2018. So if they had timely gotten their probate file in February of 18, there's at least an argument that they could have beat the statute of limitations with a personal rep that actually had all of the things that were necessary. But they didn't go back and plead that until it was too late. And so we believe that based on the pleadings and the relevant case law, that the heir status is not enough because it wasn't pleaded, and you have to have a rep in this situation where there's multiple heirs. And I think the probate code says that there's more than 2 debts. And so what's established in the record, though, is that an administration was necessary, right? Because the court actually did go back and enter letters of administration and appoint Ms. Penna as the rep. And that was the emergency motion for leave to add summary judgment evidence that was filed on June 26th of 2018 before the court's ruling. So
Well, let me see if I can understand, and I need you to walk me through this of why in Lovato, when the claim was filed and the facts were not different than this case in that the person had died, the person filed the suit, but they filed it as the personal representative of the estate, and they were not. Why is that factually distinguishable as the applicable law to this case where she filed it as arguably, because she didn't say she was an heir, but factually developed that she is an heir, but did not designate it as such? It seems like in Lovato, they are asserting a position in the lawsuit that factually does not yet exist when they say that they are the PR, but they're not.
correct, Your Honor. And that is what distinguishes both Lawrence and Lovato. And so what the cases, what those say, and what the cases interpreting them say, is that if you pled capacity you don't have, you can factually fix it later. Because I think in the rules of civil procedure, it says if there's a challenge to capacity, the court has to give someone a reasonable time to fix it. And so they said, if you allege capacity, knowing that you're going to have to do an administration, you just haven't done it yet. If you then follow through, even if it's after limitation, and cure the capacity defect, it's okay so long as you pleaded it. That doesn't violate the relation back doctrine. But if you look at some of the other cases that interpret Lovato and Dunn later, like Arns, and then there's another one of the plaintiffs like Covington versus Sisters of Charity. It says that Lovato was different because the pleadings had always alleged the right capacity, had always alleged that she was the rep of the estate. And so that you can fix later. The relation back doctrine does not let you fix it if you haven't alleged the correct capacity originally. So,
But those are capacity cases, and you're applying capacity cases to standing.
well, I'm applying capacity cases to standing only because the estate is that it has the standing and confers the standing for the purposes of the survival statute. If the pleading does not invoke the estate or plead the estate, then it can't confer standing on Ms. Pena as that representative when she files that original pleading. And it does confer standing if you've alleged that you're representing the estate, because the estate is the one that has the claim. So Ms. Pena has to borrow the capacity from the estate to file the claim. And if she hasn't pleaded that she's suing in the estate's capacity or in her capacity for the estate can't confer that standing on her. So it's a pleading nuance that has to do with both capacity and standing. So they said it's not a standing issue in the cases where it's pleaded because they pled that they have standing because the estate is who owns the claim, the estate has standing. If you pled it, it confers the standing. You also can have the capacity conferred later if you go through to the administration later. But in a case where you haven't pled that you represent the estate, you don't have standing because the estate is the only party with standing. And like you said, so I talked about the foreclosing of kind of arguing the heir argument. If an administration is necessary, then you can't file a survival action as an heir because the only party that has the right capacity and the standing is the estate.
So you're saying that it's not a pleading defect, they just never have the authority if there has to be an administration.
Correct.
Heirs.
And then once they got the authority, it was too late. It was more than 3 years after the original claim was brought. So even after the 2 years and the 1 year extension, it still was too late to go back and amend, which is why the trial court properly did not allow the pleading amendment, because it would have been after the statute of limitations. And, you know, there's some language in ARMS that says, if you don't properly plead the capacity and you don't get the standing from the estate, then the original pleading is annulled. That person has no standing at all, either on their own or from the estate to bring the claim. So there's nothing to relate back to, right? So there's a break there. So ultimately, the problem here is that because there had to be an administration as found by the probate court who appointed the administrator, the only party that could have brought this claim was the estate administrator. And because they didn't plead that capacity, they can't get the standing from the estate that they need in the original petition. So the trial court never had jurisdiction at all. And so for that reason, there's nothing to relate back to. And so the case is properly.
Are there situations where taking out the administration would be optional? Where, I mean, it's not required, it's not mandatory, therefore heirs might have authority at the time they file it, but they can go ahead and do an administration if they need to for some other purpose?
It is, as a non-probate lawyer, it is my limited understanding that it is not. That there are elements that have to be established to provide that an administration is necessary, and that a person has the qualifications or the ability to serve as the administrator. And so those findings are made during the appointment of the person who serves as the administrator.
Okay, thank you.
Anything other questions? All right, thank you, counsel.
Thank you, Your Honor.
Clear it up for us.
Thank you. I think this is a great example of what all of us have been struggling with, is kind of switching back between standing and capacity, right? I think that we have to take one thing at a time. Certainly the capacity issue based on Lovato, it's easily corrected. It's a standing issue that is concerning. So just to that point about the relation back doctrine and whether or not it would apply in this particular case, the relation back doctrine. So basically what counsel I think is arguing is almost as if we would have had to set up probate before the statute of limitations ran, which that's just not the case at all. The relation back doctrine, which was announced in Pope, which we cited the 1912 case, it says an amendment which does not set up such a different state of the facts as the ground of the action as to introduce a new or different cause of action will relate back to the beginning of the suit. That doesn't just have to do with probate proceedings or administrators or anything like that. But if the defendant knows about these claims and the claims haven't changed, then those claims relate back. So these claims have never changed, not once over the years. There is no question. I'm trying to think of a circumstance where there is a.
What was the case that you just talked about? Yeah, I think you said Poe.
Yes, Pope. Yes,
Pope.
and It's a 1912 case. 1918, I'm sorry. And the site is a Supreme Court case. It's 109, Texas 311, and that relation back doctrines discussed at page 318. So in this particular case, it seems the council would have us be in a situation where there are quite a few states that are like this, where we have to set up probate before we even file a lawsuit. And that's just not what the law is in Texas. And Lovato in 2005 really was clear about the difference between standing and capacity and the relation back doctrine. So if under the survival statute, right? If under the survival statute, which is 71.021B, a personal injury survives to and in favor of the heirs, legal rights, and estate of the injured person, the action survives against the liable person. So there's one claim, and it immediately passed to Ms. Penna. I will also point out that in our complaint, right, which is at the record at page 9, we list the parties and we state that Martha Penna brings this suit as the daughter of Celia Ontiveros under relevant case law. So, and there's no allegations of wrongful death. So I keep on trying to think how the defendant doesn't have notice of the claims or thinks that there's a new party or, you know, just we're completely blindsided by this death. There are no separate claims at issue here, none whatsoever. There's, like I said, if we would have been in a situation to where Ms. Penna passed away because of the pressure ulcers and the her losing her foot and all of the injuries and abuse alleged herein, which sometimes that happens, then that would be different, but we didn't. So under Chapter 74, there's just one claim. So standing, and then I just think just kind of talking about standing versus capacity, going back over that. Standing is whether a party has sufficient relationship with the lawsuit so as to have a justiciable interest in its outcome. That's what standing is. So does Ms. Penna have a sufficient relationship with this lawsuit so as to have a justiciable interest in the outcome? Well, certainly, once the legislature codified the survival statute, she immediately stood in her mother's shoes based on that statute. So she certainly has a sufficient relationship with the claim. And we put the defendant on notice that she was bringing the claim as Ms. Ontiveros' daughter. Now, capacity is whether the person is qualified to litigate the claim, right? So, for example, if it's and by the way, an estate cannot file a lawsuit at all. A person has to file a lawsuit on behalf of an estate. An estate is not an entity that can bring a lawsuit. So somebody has to bring it on behalf of the estate. So with that, I see my time is up. Do you have any additional questions?
Thank you, counsel.
Thank you very much.
This case is submitted and y'all are excused. statute, indictment and, charge. Good to go. Good to go. Counsel, you may proceed when ready. The court calls Rodriguez versus State, docket number 10-21-00147 CR. And counsel, you may proceed when ready.
May it please the court, Chief Justice Gray, Justice Johnson, Justice Smith, Mr. Harmon. My name is John Gilmore, and I, along with Aaron Diaz, represent Gerardo Rodriguez in this case. I'd like to start with our first two issues in the opening brief, which are dispositive to this matter. Rodriguez faced allegations of injury to a child by omission, alleging he failed to seek medical care for his 8-week-old son. Rios, child's bio mom, faced the same charges. In state, they couldn't prove who caused the child's injuries for 6 years. So 6 years later, 1 month before trial, the grand jury added a second count of injury to a child by act. The evidence was legally insufficient to convict Rodriguez for injury to a child by omission and injury to a child by act. So we began the sufficiency analysis by following the Jackson standard. And as I know this court is very familiar with, and has long been the law in Texas, jurors cannot come to conclusions based on mere speculation. That includes mere theorizing or guessing about facts. It's because a verdict based on speculation is not sufficiently based on evidence or facts to support a finding beyond a reasonable doubt. And unfortunately, this is precisely what happened at Rodriguez's trial. In viewing the evidence under a hypothetically correct jury charge pursuant to Malik, under section 2204, injury to a child by omission, Rodriguez, for the first prong, he does not dispute that he had a duty to act if these injuries existed while the child was in his care. But injury to a child is known as a result of conduct offense. That means that the state is required to prove that a serious bodily injury occurred because Rodriguez failed to seek medical care. It's not enough for the state to prove that Rodriguez failed to provide medical care for a serious bodily injury. So here, there's no evidence that Rodriguez inflicted any injury to the child by act. And further, there's no evidence to show that any delay in medical treatment attributable to Rodriguez caused the child any additional injuries. The state presented no evidence that the child's injuries were caused by Rodriguez failing to seek medical care.
Counsel, does it matter that Rodriguez did not initiate the medical care at all, that he instead returned the child in what some of the evidence would support wasn't a injured state, and it was then the parents and grandparents that initially sought out the medical care?
Well, the first prong that's required to be proven is that he had a duty to act if these injuries existed while in his care. And there's a video that the state points out and presented that attempted to support that proposition that the child was injured during the time that he was in Rodriguez's care. And there were at about 2:30 p.m. that day, Rodriguez, he took 2 videos. The state only presented one of those 2 videos. And that video showed the child waking up from a nap. He was stretching his arms, stretching his legs, making gentle baby noises, as an 8-week-old baby does. The video showed the child uninjured. There were no bruises, there were no scratches. He was not swollen. There was no bleeding. There was no dents in his skull. There were no obvious deformities in that video. And there were 7 medical professionals that couldn't say what was wrong with the child upon arrival to the hospital. This is also reflected in Nurse Wilson's reports and Dr. Elwell's reports. And so what the state attempted to do was they relied upon that video. And they had a doctor, Dr. Stern, who was the treating doctor. He's also a professor as well. He testified about this video, and he could not specifically identify any condition that the child might be exhibiting in the video. He speculated about it. He speculated that the child might be.
But does the doctor have to give a diagnosis based on the video to say that the child is not behaving as a child that is uninjured would behave? I mean, my understanding and reading of his testimony was that the the video demonstrated an infant that was in distress. And obviously, within a very short time of delivery back to the parent, Ms. Rios and grandparents, they were headed to the hospital. So, I mean, they were obviously, they didn't see the video, they just saw the child. And so my understanding was that the testimony is not about what he could diagnose based on the video, but what would a parent in the dad's position be able to see and know whether or not the child was in distress.
Understood. Well, in his testimony, he also states that it was hard to tell what was going on. And he said that context would be very important to this. And that's what's missing here. In his testimony, he also concedes he didn't expect a layperson to know what was going on with the child. And that's why it's important that Dr. Lashover's testimony comes in. Because Dr. Lashover and his staff saw the child the day before on April 2nd and said that the child was normal. There's nothing wrong with him. They physically examined him and diagnosed him. There was nothing wrong with that child. And the difference, though, in other cases, in this case, is that in Iglesias, Robbins, and Elledge, which are cases that the state relies upon, in those cases, there's expert testimony that could date injuries. There's expert testimony that could date injuries of a child within 1 hour of arrival to the hospital. There were confessions in those cases. There was other circumstantial evidence that you could point to that could show that the child was injured during the time frame upon which the suspect injured the child. And the state didn't present any of that that could date the injury. The doctors, they could not date the injury. Even Sergeant Dealey in his investigation could not date the injury. They conceded it in opening and closing. They could not date the injury. And if you cannot date the injury, then they're just guessing as to when it occurred. And guessing is not sufficient to convict Rodriguez to life in prison. And so earlier that morning, the state had focused its case on April 3rd. And interestingly, there was no evidence presented about who had primary care of the child the day before. The state had disregarded evidence that the child was in the grandparents' care the night before, like you mentioned, Chief Justice. So Rodriguez, he began babysitting his 8-week-old child at 6:30 that morning when Rios went to McDonald's for work. Rodriguez was to help his friends move their mechanic shop. He visited them at about 10 a.m. with the child. They both saw the child unharmed, uninjured. Rodriguez, he then went home, and at about 11:45 a.m., the child stood up. And that's where Dr. Lashover comes in. Because the day before, Dr. Lashover diagnosed the child with gastroesophageal reflux. Again, he and his staff physically examined the child and diagnosed. They did not see the child injured. Rodriguez then bathed the child, put on a fresh diaper, new clothes, and put him down to nap. And as the child was waking up from his nap, that's when this video comes into play. He was communicating with his family in Mexico. They asked for pictures of the child. And at about 2:30 that day was when he sent those videos. And again, those videos showed that the child was uninjured. Meanwhile, Rios was combating with her boss throughout the day, and she ended up quitting her job. She was so frustrated that she was fighting with her boss, and she gave her 2 weeks, and her boss said, "Forget your 2 weeks, just get out, leave." So Rios then, she arrived home with Rodriguez and the child at about 4 p.m. At 4 p.m., Rodriguez then left the home to go help his friends move, as he was going to do earlier. Rodriguez testified that the child was uninjured and unharmed when he left. And Rios even sent a text message to that effect too. She asked about the last time the child ate after Rodriguez had left. There was no concern about the child being hurt or injured. There was no concern about bruising or swelling when he left. There was no concern about the child being fussy. She asked if he needed to eat. And so that leaves 3 hours of unaccounted for time that the child was in Rios's care prior to her taking the child to the hospital. And the evidence showed that Rios and the child spent at least 2 hours at the grandparents' home with 6 other people before taking the child to the hospital for a reported fever at 7 p.m. And only half of those people were ever interviewed. And an injury like this could have occurred in a split second, as Sergeant Healy testified to. And while at the hospital, Rios, she's texting Rodriguez. And she said, hey, the child has a fever. We're taking him to the hospital. And Rodriguez responds that, is everything okay? He was fine when I left. And Rios says, he just needs medicine and he'll be okay. So in all, there's 7 medical professionals who testified. There's 4 doctors and 3 nurses. Not one of them could explain who injured the child. Not one of them could explain how the child was injured, nor when the child was injured, again, including Sergeant Healy. But rather, these medical professionals, they testified about general results from traumatic brain injuries. That's after they performed brain scans. That's after they performed lab tests. That's after they actually treated this child. And they had the benefit of knowing what was wrong with this child. And that's typical in these types of cases. But here, the experts, they could not develop a timeline as to when these injuries occurred. They were just described as old and new. There was some old blood and new blood. And that's unlike the cases that the state relies upon, when you could develop a timeline, when you could expertly date these injuries, when there were confessions involved.
Counsel, I know you want to focus on issue 1 and 2. As sufficiency issues, we're going to plow through the record and we're going to spend the necessary time with those issues. But with the leave of my colleagues, I'd like to get you to move to the double jeopardy issue, because
Understood, Your Honor.
we definitely need to get to that and spend some time with that.
Understood, Your Honor. So Rodriguez,
Yeah, yes, sure.
Rodriguez's conviction for both counts 1 and 2, it violates the double jeopardy clause. Here, the state alleged the same conduct for the act and the omission. That is, they charged Rodriguez with injury to a child by causing serious bodily injury and injury to a child by omission for that same bodily injury. And the jury convicted Rodriguez for both the act and the omission of the same conduct on April 3rd. Thus convicting and punishing Rodriguez twice in a single criminal proceeding. And so what the state attempts to do is they attempt to analogize Rodriguez to your decision, Chief Justice Gray, in Borden. And Borden is distinguishable from the facts here. In Borden, as I was mentioning earlier, there was medical experts that testified. And they testified that the child sustained at least 2 or 3 separate, significant, and discrete injuries that were inflicted several days to a week apart. The doctors could date those separate and discrete injuries. There was also testimony and a confession about Borden being violent. And the evidence in Borden established that the child was injured again on more than 1 occasion. And so the court had reasoned that that means it was not serious bodily injury against the same victim at the same time, making it multiple punishments for the same offense. But here, the state did not and could not show 2 separate and discrete incidences that occurred on that day, compromising 2 violations of the same offense.
You focus on incidents, but Borden was focused on different damages. And I think my understanding of the statute is it is the injury that is the cause is the trying to find the right word. It's not the cause of action, but it's the cause for criminal liability is the causing a particular type of injury. And I just have to ask, have you seen the Court of Criminal Appeals decision in Nawaz versus State from June 22 of this year?
We have, Your Honor.
How do you square this case, your case, with Nawaz?
Well, I think Nawaz, if I remember correctly, I don't have it in front of me, but if I remember correctly, it didn't focus on this exact issue. It focused on, I think there was another case, Stuhler, I believe is what it relied on. And it looked at jury unanimity, not whether or not there were separate and discrete incidences. But here, Rodriguez is like Borden, in that the court in Borden said that there were different injuries. There were different injuries. And there were injuries that were inflicted on several days or weeks apart. And so here, there was no dating of injuries. Nobody could tell you there were two separate and discrete incidents. And so what ended up happening, it was Rodriguez, he was convicted for the same thing, for the same act and the same omission against the same victim. This has nothing to do with jury unanimity. It's all about whether or not he was convicted and punished twice in a single criminal proceeding for the same thing. And so again, there's no evidence that Rodriguez injured the child at all. The state did not present any evidence of a separate injury by Rodriguez's alleged failure to seek medical care. And instead, the state re-indicted Rodriguez 1 month before trial. They speculated that the alleged bodily injury and failure to provide medical care to the child occurred simultaneously. That was the state charging Rodriguez with act and omission. Those were two means of alleging or proving the same offense. And therefore, these punishments under both counts in the indictment violated the Fifth Amendment's double jeopardy clause. The interesting thing is the remedy. What's the remedy that we get? After briefing was completed and in preparing for these arguments, we found that the Court of Criminal Appeals may have provided us a framework. It's in Bien v. State. That's B-I-E-N v. State. That's 550 Southwest 3rd, 180. And that framework in Bien v. State, it talks about the remedies if a double jeopardy violation occurred. And so, as we mentioned in our brief, Ex parte Cavazos, that case developed what's known as the most serious offense test.
Which can't apply here. Wait, I'm trying to save you time. Most serious offense doesn't apply because it's the same offense, same level of punishment.
Right.
Skip to
And
the next.
the same thing in Villanueva, as you know, Chief Justice. The difference in Villanueva, they looked at parole eligibility too, and there was a finding of deadly weapon. There is no difference here. Each one is exactly the same. And so if a tiebreaker is what these are called, if there's a finding of a deadly weapon or something like that, or if restitution is higher, if a tiebreaker is not sufficient, then what Bien states is that the appropriate remedy is to retain the offense the state chooses. So regardless of which count the state chooses to retain them, we'd still argue that the evidence is insufficient to convict Rodriguez on both counts. There's no evidence to prove that there was an intentional or serious, knowingly seriously caused bodily injury to the child. There was no evidence to prove that a serious bodily injury occurred because Rodriguez failed to seek medical care. The witnesses that day that actually saw Rodriguez with the child, they testified that the child was uninjured, and that was disregarded by law enforcement. That video, again, it was inconclusive. That video showed the baby uninjured. The doctor speculated as to what was happening. And he importantly said that context would have been important. And the context that's missing here are the messages that were surrounding it, where Rodriguez, which are unfortunately not in the record, but Rodriguez testifies about them. He testifies about him sending this video to his family because they wanted to see his sweet 8-week-old child. And of course, the doctor, the medical professionals, all 7 of them, they couldn't testify as to who inflicted this injury, as to when these injuries occurred, as to how the injuries occurred. And so there wasn't enough evidence to convict Rodriguez. And of course, medical professionals, when in the other cases, they could date these injuries. They could say this happened within an hour of coming to the hospital. It's possible.
Is there any testimony in the record about how long it takes a bruise to form on an infant of 8 weeks?
No, but there is a concession by Sergeant Dealey that an injury like this could have occurred in a split second.
I know it can occur in a split second. What I'm interested in is if there's any testimony in the record of how long it would take the bruise to be evident to a visual examination.
There was no evidence of that. No evidence in the record of that at all. And guessing about when it occurred and who inflicting these injuries, it's not enough. And a verdict based on guessing is not sufficient to support a verdict beyond a reasonable doubt. And with that, I see I'm out of time and I'll reserve the rest.
Address the bruise that was evident that everybody concedes was evident on the head, as I understand it.
Yes, so the testimony was that Rodriguez asked Rios about that bruise. Dr. LaChoper, again, he saw the child the day before. He and his staff saw the child the day before. They examined and diagnosed the child. If it was a concern, that doctor testified that, and he and his staff would have at minimum noted it in their report, and they would have had to report it to law enforcement, and they didn't see it. It was not there. And that's not enough for the state to prove that Rodriguez failed to provide medical care for that faint bruise. That's not why we're here today.
Okay, thank you, counsel.
Thank you, Your Honor.
Counsel, you may proceed with the record.
May it please the court, counsel. I'm gonna start off not with a concession so much as the state's comprehension of the being waiver holding that if a parent causes an injury to a child, and that's the end of it, and you don't seek the medical attention, that if you find that parent guilty of causing the injury by act and omission, that is a double jeopardy issue, in which case one of those convictions has to go away. I'm not going to argue that an April 3rd injury without any reporting is what happened here. Got a kind of pitch to my trial team as to what the actual theory of the case was, in that the appellant committed this offense, and it was apparent that this child was in need of medical attention. As shown in that videotape, which essentially those doctors said, what you're seeing there is a seizure. And what happens when you break a baby's brain is that you've done that injury. And as Dr. Stern, I believe it was, testified that if you do not get that child the medical attention that it needs, it's going to have seizures. And those seizures will compound and increase the degree of injury. Thus, immediate medical attention is needed to prevent those further injuries. There was medical testimony that LR, the child, continued to experience seizures and was on seizure medication, had all kinds of debilitating brain injury that will affect him his entire life. I believe that is what our trial team's theory of alleging both of those counts was. And frankly, if after this court does its sufficiency analysis and finds that the evidence was not sufficient to prove some sort of different or additional injury beyond the infliction by the act on April 3rd, that but finds that there's sufficient evidence, but there's a double jeopardy bar if one of those convictions is vacated. Frankly, I don't think that we're going to ask the Court of Criminal Appeals to review that. The sentence has been noted that these are identical sentences for both maximum punishment, 5 in prison and a $10,000 fine.
Let me make sure I understand. You talked about not a concession, but an observation. Are you saying that if there is sufficient evidence under both you agree to the double jeopardy issue?
Yes, and of course, I got 16 minutes to go here. I'm not, like I say, I'm not making the concession that that is all that the record shows. If in your review of sufficiency on infliction by acts and injury by omission, that you find that those are identical, then of course, we understand what Villanueva says, that one of those convictions has to be vacated, and the remedy would be to vacate the second verdict.
Okay.
shown on the verdict.
I've got to ask if you're familiar with Nawaz from June 22nd.
You have the advantage of me.
Okay. I'll expect post-submission briefs, then I'll just tell.
I
address it that
expected
way.
to write one when I heard the word.
So, and while I'm thinking about it, counsel, you cited a case that was not in your brief. You need to be sure and in the either a letter brief with just that, or if the state files something, and you may want to revisit Nawaz as well, because it was a double jeopardy case. So we'll be looking for some briefs, but I digress. I interrupt your argument. I apologize.
And I appreciate, do you feel there's something about Nawaz that's light bulb, eureka? Sorry, I need to pull all of this back. Is it to that extent?
Well, from my perspective, one of the things that the Nawaz case and its little interlineation says is distinguishing Villanueva. And I think the court in Nawaz looks at the difference between whether or not the injury was caused by act or omission, and what kind of bearing that had on how many offenses the defendant could be punished for.
Okay,
And it might not be the same result under Villanueva as it would be in this case based on these facts.
okay, so a differentiation, but not an overruling of Villanueva.
Yes, sir.
Okay. And Villanueva holds, I guess in dicta, that the state didn't prove the two different separate injuries, but the Court of Criminal Appeals held out that in any particular case that the state can prove additional or incrementally greater injury due to the failure to the omission, the failure to seek the medical treatment. I have analogized the case at bar also to this court's opinion in Borden, in which case there was evidence of a different injury. And in this case, the medical testimony did show that there was both old blood and new blood in this baby's brain, indicating that there was, and it's phrased, acute and chronic. The timeline of events is such that the acute injury must have been inflicted on the afternoon of the April 3rd, the Good Friday. And I say that because at 10 a.m., the appellant went with the baby to visit the Lozama brothers, and both of them testified that they looked at the baby and the baby was just fine. Didn't see anything, and that's undisputed. The video was taken around 2:30 in the afternoon, and it shows essentially this child having a seizure. So the infliction of that was between 10 a.m. and 2:30 p.m. And the only person who had custody of the child during that period was the appellant. So the
Counsel,
argument,
do you agree with opposing counsel that there's nothing in the record about the amount of time that it would take for a bruise to become evident to the naked eye.
Oh, I agree with that, but I don't think that's necessary to even be put into evidence, because I think a reasonable juror understands how long it takes for a bruise to form. Everybody's gotten a bruise, we know how long it takes, several hours to a day or so. You generally, it appears overnight. That's common sense. That's within the realm of knowledge of any juror, would be my response to that. Also, I don't believe that the appearance of the bruising is necessarily dispositive to the appellant's awareness that this is an injured child. And you can look at I think opposing counsel has been very liberal in his interpretation or his editing of the record in regard to what the medical testimony is. I think it was 3 doctors all testified that the only way to break a baby this way is to slam it or shaking. That's from Dr. Ward, Dr. Stern, and Dr. Elwell. All 3, I think, testified that babies are tough. You can't do this to a baby any other way unless there is some horrendous accident which you would have an explanation for, such as a car wreck.
As I understood opposing counsel's argument, it wasn't that there was a very serious medical problem with LR, that the doctors all agreed that this baby was seriously injured.
Yes,
The question in this case that the state had to prove is that he did it, and that's what that testimony doesn't cover, is that he, during that time frame, was necessarily the one who.
certainly, and that testimony couldn't have come from the doctors because they were treating the child
Sure.
post-injury. What shows the infliction of the injury by the appellant is the undisputed timeline. The Lozano brothers saw the baby at 10 o'clock, he was fine. The video was taken at 2:30. That shows that child having seizures, which had to have resulted from this traumatic brain injury. During that time, appellant was the only person who had custody of that child, who had the care and control of the child. Nobody else did. And the case law indicates that the infliction of the injury, the nature of it, the severity of it, would indicate a knowledge and intent to actually inflict the injury if you only have one person in control of the child that could have inflicted the injury. The case law also.
Counsel, not to make appellant's arguments, but is the testimony going to negate the suggestion that this injury could have been caused by Rios during the night or the evening before and only manifested after the meeting with the Lozano, I believe it is, the Lozano, the body shop? Or
Well, I think that question kind of suggests a wandering back to Giza. That might have been a theory that was posited, but the state didn't have to absolutely disprove that theory.
But it had to prove that the injury occurred in a window
Yeah.
when only he had access to the child.
Yes, and I believe that is proved.
And my question is there testimony that says this type of injury could not have occurred before 10 o'clock? Because it takes time to manifest. In other words, even bleeding on the brain, that from the moment that it started, whatever the event was that started it, then immediately it's not a problem until there's enough blood that's bled out within the brain to create the pressure. And that's where the problem becomes apparent. Is there medical testimony about that?
Well, I'm not sure if that's the proper way to look at it, because I think you're looking at what is the knowledge of the appellant. if you don't know that a baby's sick because there's nothing apparent has happened in regard to the omission, then you got King's X there. But
Okay,
but once you see a child having a seizure, and all of these doctors testified that, yeah, you don't have to be a medical professional to see there's something really wrong with this kid, and this kid needs help right now. So that goes to the omission.
As opposed to the act. of
Yes.
Having caused it. Okay.
Yes. But also, the evidence is sufficient for reasonable jurors to have found that during that window between when Mama left for work, when the Rosales brothers saw that baby and he was doing happily and what have you, and the making of that video at 2:30 in the afternoon, that a reasonable juror could find from the evidence that was presented that he, during that period, inflicted those injuries which caused that brain damage. Going back to, and I think I've really been talking about general sufficiency, but in regard to double jeopardy issues, I'd ask the court to look at the evidence in this case rather holistically and not automatically assume, and I address this in the brief, that the only injury was that of April 3rd, and that the only omission was the failure to report or seek medical attention at the time or shortly thereafter. And as I said, I believe that the trial team's theory was that the additional injury that is mentioned in Villanueva is there because of the failure for Don to seek that medical attention, because he saw the child having a seizure, and the child continued to have seizures until he was put on the Keppra at the emergency room. But also the evidence of the old blood indicating older injuries, which is analogous to the Borden situation. So a reasonable juror could have found also, as in Borden, that there was an infliction earlier, either by Rios or appellant, and there was Rios took the child to the doctor, but the doctors who did the examination didn't indicate anybody ever told him, well, you know, we slammed the baby's head into the table. That might account for his eating difficulties. That was never done. Certainly appellant never made that assertion that would have been helpful, and not just failing to seek medical attention, but failing to provide a medical professional necessary information to make an accurate diagnosis and perhaps do something to assist the sick child. So the overarching matter is, I would ask the court to look at this holistically as not just one simple act and one simple omission, but there is a constellation of acts and omissions that were involved with this child. Like I say, I believe the trial, the state's trial attorneys forwarded a particular theory, but there are certain others that I believe are cognizable to find no double jeopardy violation under Villanueva and Borden. If there's no other questions, I believe I've covered the state positions.
Thank you, counsel.
Thank you, Your Honor.
You may proceed when ready with your rebuttal. You've got 5 minutes.
Thank you, Your Honor. So Nawaz deals with the difference between count 1 and count 2 based on act. There are 2 acts alleged in Nawaz. So Stoller applies in that case. Nawaz specifically stated that Villanueva applies to act and omission, which is the case here. And of course, Your Honor, we will submit a post-submission brief as to that and as to the end. And so in Nawaz, Stoller was controlled. And the Court of Criminal Appeals, they did address Villanueva only to show why it was inapplicable to the facts in Nawaz, given that there were two acts instead of an act and an omission. Now, with respect to all other omission cases have circumstantial evidence involving an abusive history, a history of violence. The home is dirty, it's filthy. And sometimes there's admissions from other people saying that this person had been violent to them in the past. None of those are here at all. Even Sergeant Dealey, he went to the home and he said, clean home. Those are his words. That's what he testified to. With respect to the bruising, there was no direct testimony about when bruises occurred, when they could have occurred. None of that was in the record here. But there were reports that show a low iron count to the child upon arrival to the hospital, which certainly could have been, not a medical expert. Now, speaking back to that infliction of these injuries between a presumed window. Again, there's no testimony that says that a window between 10 a.m. and 2:30 p.m. An injury occurred. That's not the case here. There's no facts, no evidence of that here. They had, again, 7 medical professionals come and testify, 4 doctors, 3 nurses. Not one of them could date the injuries.
Would you agree that some of the doctor's testimony and or the nurse's testimony disagrees with your characterization of what the video shows, that it showed a baby in distress?
I believe that Dr. Stern's testimony, if you look at it closely, he talks about, again, keep in mind, this is after he's conducted lab tests, after he's seen brain scans, after he's treated this child. He says he could not specifically identify what was wrong with the child. He couldn't identify what condition that child might be exhibiting in the video. And keep in mind, he had the benefit of knowing everything that had happened to this child. And he speculated that the child might be having a seizure. But again, his testimony is, it's hard to tell, and that context would be important. And so I don't think his testimony directly says that a seizure was happening and anybody should have known. And in fact, he concedes that he didn't expect a layperson to know what was going on. And there's also some in these cases, the circumstantial evidence. The state, they rely upon Rodriguez when he arrives at the hospital, seemingly being disinterested while he was there. They may be conflating being disinterested with being confused. So going back to what's on the record, going back to what the testimony does show, is that when he left the child with Rios at 4 p.m. that day, he left the child uninjured. And there are text messages that back that up. There are text messages where Rios was not concerned about the child with a bruise, was not concerned about the child with a swollen head or him crying. She was concerned about whether or not he ate. And when he left the child with Rios, the child was uninjured. And when 3 hours later, Rios sends a text saying, hey, I'm on my way with my mom and my uncle to the hospital. The baby has a fever. He's hot. He's got a 101 degree temperature. Rodriguez again reiterates that. He says, everything was okay when I left. What's wrong? I'm on the way. And then Rios says, oh, don't worry about it. It's just medication. He just needs medication. He'll be okay. And thirdly, Rodriguez, he only speaks Spanish. No one's telling him what's going on at the hospital. Rios is not telling him what's going on at the hospital. And that's why he called De La Cruz. So imagine you're in a foreign country and your child's at the hospital. No one's speaking your language. How are you supposed to know what's going on? So there's no evidence that exists to prove that Rodriguez caused these injuries. And as such, Your Honor, we'd ask for both counts 1 and 2, that they be reversed and rendering of acquittal be.
Thank you, counsel. This case is submitted. Do need those post-submission briefs. What timing are you interested in? Friday or a week from Friday?
Not Friday, a week from Friday.
We can try to sound.
Week from Friday. So you got basically 10 days.
Yes, Your Honor, we will comply.
All right.
Thank you.
This case is submitted and y'all are excused. The court's going to take about a 5-minute recess.
Mr. Green, want to approach?
Aye.
At this time, the court will take up the case of Sam Ukwachu versus State of Texas. And I will take announcements from. So you'll find my document sheet, announcement from council.
Helen, ready?
And your Counselor Bratton,
I am.
you'll be making all the arguments today?
I will.
Okay, thank you, counsel.
John Messinger, Assistant State Prosecuting Attorney for the state. The state is ready, and I'll be making all the arguments.
Okay, thank you, counsel. The time is for 20 minutes for each side, 5 minutes for rebuttal. One of the cases today, we were asked to save some time for rebuttal and add to it. We don't do that. Whatever you give us back at the end is we take, but other than that, counsel, you may proceed when ready.
Thank you, Your Honor. Again, I'm representing Sam Ukwachu on this direct appeal from a conviction for sexual assault here in Clinton County. For the benefits of Justice Smith, Justice Davis, just very briefly, this case was tried back in 2017. Appeal was reversed on an issue that was briefed under seal regarding text messages of the complainant. It was taken up on discretionary review by the state. Court of Criminal Appeals reversed the judgment of this court, sent it back for further disposition. It was again argued, and that was about 2018. It was re-argued, and there was a new briefing after remand by the appellant. It was argued again and again. This court found error and reversed the judgment of conviction. The state of Texas again took it up on discretionary review. The Court of Criminal Appeals reversed the court's decision. And that time it had to do with two witnesses, Penny Tagu, and another witness that he was driving him to the home, and he was a roommate of Sam Ukwachu. And again, on discretionary review, the Court of Criminal Appeals reversed the judgment of this court and sent it back, and that's where we are now. The last briefing on the issue I'm going to argue occurred after the first remand. We didn't rebrief it after the second remand, and so it's point of error 5 on the original brief and in the brief on the remand. Now, the case itself is basically an allegation of sexual assault by the appellant, and the primary issue was consent at the trial. The issue of consent had to do with why we're here right now on issue 5, because what this deals with is a witness that was going to be called on by the defense named Penny Tagu. And Penny Tagu was a roommate of the appellant and was testifying as to facts that would contradict the testimony of the complainant in the case on things that were going on in the apartment while the alleged sexual assault occurred. Now, let me stop kind of right here and deal with the court on a couple of things. I have to admit, as far as a case that I've ever dealt with before, and I've been doing this for a little while, I've never had a case reversed twice and sent back for an argument the third time. Secondly, I've never quite seen the events that occurred in this one play out anywhere else before. And I'll tell you why. And this is central to the issue of the reversal by this court on the first remand and the issue now before the court. And that is, while the case was being tried, the prosecution came up the second day of trial with some records that apparently were subpoenaed or obtained from AT&T regarding cell phone records of the witness Penny Taki. Now, these records, without question, were never introduced. They were never testified to. They were not part of the record. But yet were kind of central to what the state did during the balance of the trial. And basically what the last reversal had to do with is when Penny Taki testified, the records were said, these records show that what you're testifying to is not true, that you weren't there, you were all over town, you weren't where you said you were, because these records show that. Yet there was never any evidence, nor did the defense introduce any evidence. So these were just arguments made with some paper in someone's hand that were being used to try to impeach the witness's testimony. Now, what we're here today on is that, and these are the facts that really are just not controverted. This case was indicted in 2014. And at the time, after the indictment, or at some point, there was a written statement by Penny Taki of what his knowledge of the events, and it was dealing with the events of October 19th to 20th of 2013. And he gave a written statement of what he knew about the events that were alleged to occur in the apartment where he was he also lived with Sam Ukuwachi, the appellant. As it progressed for trial, Mr. Taki was subpoenaed to the grand jury here in McLennan County on July 22nd, 2015. Now, there were some events around that where he was subpoenaed, he didn't appear, he ended up having an attachment, placed in jail, ultimately released on bond, and ultimately testified before the grand jury. Now, the state is going to argue that this was something we do because we had some sense that there was witness tampering going on. Yet the request for him to be there was to testify regarding his knowledge of the events of October 20th, 2013.
Was that in the subpoena?
Yes,
The scope of the subpoena was about the events.
right.
Have you ever had access to, or is it in the record, the grand jury testimony?
No, never seen that.
And I need to step back on one other question, the phone records, the digital data printout.
Right.
The state had attempted to introduce that at some point, and the trial court denied the admission. Was it never marked by the state during that process, or
No.
do you, okay,
No, they tried to introduce it as business records. Of course, it came in 2 days after trial started. There was no business records affidavit. They didn't subpoena or bring a sponsor for that. And their position was these, and this is kind of off the record, I mean, not in front of the jury, on the record. These are going to show that Penny Taki is lying about being in that apartment and making phone calls. And in fact, Penny Taki was subpoenaed by the state and the defense. And he complied with the trial subpoena, and on the 19th of August, appeared with his attorney as required by the subpoena. And at that time was confronted by one of the assistant DAs, Robert Moody, and told, look, you may not want to testify because we're going to indict you for 2 counts of aggravated perjury. One, what you said here, and the other one, what you said in the grand jury, because these records show that you're lying. In essence, I'm not quoting that exactly. Also, it should be noted that the person who questioned Mr. Taki in the grand jury was the assistant district attorney trying the case, Mr. Moody. Now, I think this point of error has 2 levels to it. One of them is the use of the grand jury in this matter. And the second is how Sam Ukuwachu's rights would be impacted by the use of the grand jury in this way by prosecutors. Now,
Council, the one thing that as you know, I've been here for the duration. I think Rex has been here for the duration. We've had problems with the fairness of this trial, and one of the issues that the Court of Criminal Appeals reversed us on in the last case was a preservation argument of the fact that these cell phone data was not introduced into evidence or not available in the record. We're here now, the fifth issue of how the abuse of discretion or prosecutorial misconduct may have impacted Taguiv's testimony. But I need you to walk me through preservation and how we get there. Does it need to be preserved under Marin? Where are we?
all right. So the way this unfolds is these records are brought to the defense's attention that the state has them 2 days into a jury trial. At that point, to introduce those, first of all, the defense had no knowledge of it until that time, and in fact, requested a continuance to review them, and so the court gave them the afternoon to look at them. The only thing that they could, and I think the record demonstrates this, could show right off the bat, is that the timing of these calls is under what they call UTC and not Central Daylight Savings Time here in Waco. So the UTC put it about 5 or 6 hours off of what the actual time that the calls were made in Waco. Now, and this goes to preservation too, and this is, I understand the Court of Criminal Appeals all along has said, you haven't proven that those records are false when they say they are. You haven't proven what the records are. You haven't introduced those records. The defense got these in the middle of trial and were given one afternoon to deal with it. Now, could they have been marked and made a part of the record? Possibly, but that certainly did not keep, because, back up, the assistant district attorney trying the case, Mr. Moody, certainly wasn't deterred when he realized that the timing was off from UTC to Central Daylight Savings Time in Waco, because he went forward even more and more saying over and over again, these records show you're not telling the truth. Now, and this goes back to where I started about this being a consent issue, because the testimony of Penny Taghi that he was in the apartment, heard nothing from this room where testimony was that screaming occurred and protestations and all kinds of sounds were occurring. He heard nothing. He heard nothing. So they don't impeach on that. They impeach on you're lying because you weren't even there. These records show that. Now, and this is a little bit, I guess, a pet peeve as part of a defense lawyer, to put the burden on the defendant to prove those records are not true when the state is the one saying they aren't, and they're the ones who got them, and they're the ones, if they're going to use them, they need to prove they are true if they're going to use it. If they don't, and they say it isn't, the defense didn't have really even the opportunity during the course of the trial to do that.
So where does Marin come in?
Marin comes in because of those first two categories of unobjected to error that deal with substantial rights. And these, and you know, here's the thing, state, if I have this right, state's going to argue it wasn't preserved. Okay, there wasn't an objection, and there wasn't. Okay, no evidence, because they say the affidavits of Penny Taghi and his attorney that were introduced during the motion for new trial do not, or I think what they're trying to say is if the court denied the motion for new trial, then the court inherently found those to be untrue. Okay, yet there was never any contested issue about those, and in fact, the prosecution admitted that they went to Penny Taghi and told him, and in the record, not before the jury, the prosecutor says he's gonna take the fifth. So we don't even need a continuance. Penny Todd even gonna come, he's gonna take the fifth. Why would he have taken the fifth? Unless the discussions between the assistant DA and Penny Todd even his attorney, as verified in the affidavits produced at the motion for new trial, weren't true. They're true. And then they say, well, there's no proof of the records that they're inaccurate. Well, there's not proof of that. And then finally, they're gonna argue there's no harm because Penny Taggy testified. And this really kind of gets to it. So the argument is by the state, we can do this unless you prove that what we're doing is not true. That's their argument. We can say these records show that he was all over town unless you can prove that what we're saying is not true. And we can call a potential critical witness before a grand jury on an indictment that's already been returned. Now, they're going to argue, and fair enough, that's what they want to argue, that we were investigating witness tampering. Well, I don't know where that came from, except that Penny Taggy didn't appear the first time, but then they arrested him and he testified the second time. If that's legitimate, you know, if they can actually in good faith say, we believe there was witness tampering here, then okay, so you subpoena a potential critical witness for the grand jury. The only problem with that is 3901 of the Code of Criminal Procedure sets forth taking depositions. And depositions, if ordered by the court, have the defendant and his attorney and the state there together. What they're doing is taking someone in a room with grand jurors, no attorney for the witness, no presence of the defendant or his counsel there, and ex parte a witness. So if that is okay, then why didn't the prosecutor do that every time going into a critical case? Look, let's just subpoena their key witnesses, put them in the grand jury, and then even after indictment. Now, I understand if you're investigating this. If, in other words, during the investigation, they get a statement from Penny Taggy that says this, and you want to call him as a witness to verify that or not before indictment, I think that's what the grand jury is for. Besides, we haven't even gotten to the issue of the secrecy of the grand jury. Whatever goes on in the grand jury is supposed to stay in the grand jury unless ordered by the court to be distributed. What we have is a trial prosecutor 2 months before trial walking into a grand jury, questioning ex parte a witness, a key witness, the roommate of the person accused, and then coming to trial, popping up with records that they haven't verified, accusing him of lying, telling him, don't testify, we're going to indict you for 2 counts of aggravated perjury if you do. And yet he does because he knows he's telling the truth. And so they're going to say, well, that's no harm to Mr. Hukawachu if you, the day before, threaten, or not threaten, let's not say that, that's not the right word, advise a witness, we're going to indict you for aggravated perjury if you get up there and testify the same way, because we have records here that they don't even know that they can do that with. They don't even know what it says, apparently. Because if they did, they would have introduced it. And so now it's going to be upon the appellant. Well, if you didn't prove that, then we can go about our way doing this any way we want to do it. And if they testify, no harm, no foul.
If I understand your argument, we're at the point of your point is an abuse of the grand jury process, and that the way it was used was a deprivation of due process, mirroring at least category 2, if not a category 1 unfair trial.
Right.
Okay.
Yeah.
Does that address your
I think
preservation?
you're absolutely there.
Okay.
I would now. The way our system works, though, unless Barron is your home run, the fact of the matter is, we've got to go fully through this direct appeal, this third one, before we could also reach habeas. I appreciate the fact that I've read the state's briefing, that I would suggest generously and creatively, I'm complimenting that, suggest habeas. Well, of course, you could make a record of all this stuff, but you can't reach it, can you? Not even in the question of a fair trial can you run them side by side. There's just not a way to do it under our system. Am I wrong about that, or is that the way we are?
No, and again, frustration by appellate counsel. Even the Court of Criminal Appeals in its last decision says, well, maybe if this had been structured as a prosecutorial misconduct, maybe that works. Yeah, we're gonna rescind this back as not being reversible error. Now the state's going, well, maybe if you file a writ and prove these facts, maybe you win. So it's maybe not correctly, it's frustrating that you've got this kind of record, because these facts are really, they're not in contravention in any way. It's just saying, well, the law doesn't allow this because basically you didn't object. There's no evidence of it because those affidavits weren't there. There's no proof the records were really false, which the state didn't do either. And there's no harm because he testified. Now, here's the only thing I'm saying about harm about him testifying very briefly. And I do know that the state's pre-argument brief says that this court has, quote, no obligation to construct and compose appellant's novel preservation argument for him. I'm not asking the court to do anything like that. Okay. It is novel because I don't think I've seen facts like this really. But if you have a witness get up there to testify after they've been threatened like this, I say threatened, excuse me, advised of possible consequences of them getting up there. And you have a prosecutor waving documents saying, these say you're not telling the truth. You have 12 people over there watching all this. Now, I'm going to tell you, as a trial lawyer, they're listening to all of that, and they got to believe those documents because you want to believe that prosecutors always wear the white hats, right? So if they're saying that these say you're lying, they probably think he's lying. But they're going to say, the court's going to say, unless you, the defendant, prove that those documents are waiving, aren't what they say they are, that doesn't have any effect on the jury. So it's exactly Justice Gray laid out exactly what it was. I probably wasn't as clear about that, but that's what it is. Under Marin, I think it's either class 1 or class 2. And I think it absolutely impacts what went on at trial on this. And I think the case, based on the activities of the deprivation of his due process rights, the abuse of the grand jury, that the case should be reversed.
Thank you, counsel.
Will you get anything about 24 out of them? You spent on which I'll find it. You want to get it back on the other end?
Yeah.
All right.
Counsel, you may proceed when ready.
May it please the court. The reason everybody involved in this case has questions and concerns about what happened at trial is that the record doesn't tell us what happened at trial. Not in anything that matters to the issue we have before us today. Starting from the beginning, in terms of preservation, it would be an interesting question to ask whether or not obvious abuse of the grand jury process or the perjury warning process is something that wouldn't have to be objected to at trial. But we don't have a record that says that happened. All we can gather from the record is that the state got record that they believed made it look like the roommates testified falsely to the grand jury. We have from the record the idea that the first thing that the state did was approach that witness who was represented by counsel and spoke to both of them together and said something about it. Mr. Moody is not on record as saying anything about the nature of the warning. He just says, I spoke to them. We have these phone records. That witness may be taking the fifth. That witness's attorney on the record says, we were thinking about it. I want to look at the records. And then Judge Johnson gave everybody the evening to look at the records. Mr. Sibley had the opportunity to look at it, make whatever objections he needed to make, and he did. He made the objection that they were not given enough notice of the records, and so Judge Johnson kept them out. The issue of whether or not the records were accurate was never taken care of at trial. It didn't have to be because they weren't going to be admitted. That's as far as defense counsel's objection went. And obviously, the roommate's attorney spoke with him and they decided, go ahead and testify. This is a case that has no record to support any misconduct and no record to support any harm. I don't know how you blow off the idea that even if it hadn't been decided by the Court of Criminal Appeals, that the person who was supposedly intimidated was defiant in the face of said intimidation, took the stand, testified, as Judge Slaughter writes in her opinion from the last case up there. You know, he was cross-examined fairly aggressively, and I think the record would support that. And he stood by what he said. And I should note that at the back end, he wasn't tagged with a perjury charge for either what happened at trial or what happened in the jury. So I'm not sure what to make of this claim just at the back end. You would have to not only create an exception preservation when something can't be told from the record. You can't see that there's obviously abuse of the grand jury process. And at the back end say, we don't really need to do a harm analysis. We are so offended by what the state did that we're just going to say, completely unrelated to what happened at trial and the fairness of the trial, we're going to reverse this and send it back.
Counsel, I've got to ask what you mean by back end. Are we talking about subsequent events that confirm that Teague was not indicted?
No, I'm sorry. I just mean, you could start at the beginning, which is preservation. That's typically how you would do this. And this is a novel issue. I'm suggesting that if you skip to the end and say, assuming this did need to be preserved, assuming we could even look at this record and decide that it shows not a prosecutor who is allowed to use the grand jury process for a witness, allowed to present to the grand jury potential witness tampering, that this is so obviously bad on its face, and yet nobody objects. If you can put all that on a shelf, you still ask yourself, to what end? These cases are classically about making sure the defense's witness either doesn't show up or doesn't testify. Sometimes it's somebody else, sometimes it's the defendant. But in either event, that's what we're looking for in these cases, because that's the connection between violating some other third party's rights, in this case, the roommate, and the fairness of the trial. And if we can look at this record and say, well, the roommate testified. He says he doesn't really change his testimony in the face of aggressive cross-examination. And in the motion for new trial, he files an affidavit saying, I was nervous, I was unnerved, but I testified. I knew what I was saying was right, and I testified. I don't know what possible harm you could conceive of in this case. I think opposing counsel.
Isn't this case all about credibility?
Most cases are.
And when you've got the, shall we say, the only third party present, and that person, because of what is going on, has to go hire their own lawyer to counsel them about their testimony and giving the testimony. I mean, isn't that some indication that this one is different than the norm?
I think that's true. I think the fact that this is not the sort of thing that happens in usual trials suggests that something extraordinary happened in this trial. It doesn't tell you whether or not it was because the witness was extraordinarily recalcitrant. Surely ignoring a grand jury subpoena is not normal. I hope it's not normal. The idea that one would be attached for blowing off the grand jury doesn't seem out of the norm. So yes, this is extraordinary, but I would argue that without knowing more about it, it suggests that Robert Moody would not have done this had there not been something he suspected was afoot, tampering with a witness or something of that nature. We can develop this record at some point, just not in this proceeding. So
So you're suggesting, as Justice Davis did, that this may be a writ case as opposed to a direct appeal case?
I'm telling you, it's definitely not a direct appeal case. And the only opportunity you might have for relief is to have a writ that explains the record, because you're articulating a theory of harm, that it isn't that he wasn't deprived of the witness. It's that possibly the impact of the witness was impacted by vigorous cross-examination, the sort that we anticipate both parties are going to do. Well, whether or not that cross-examination was unfair hinges upon whether or not the impeachment material was accurate. And the CCA decided last time up, we have no idea if that's true. And so I can conceive of some sort of claim where you're not saying that false evidence was elicited because the roommate says he testified truthfully. So now you're inventing some sort of claim.
Which is straight up, as I understand the issue, it's a straight up due process violation for the absence of a fair trial caused by the abuse of the grand jury process, going into violating the rules regarding how a grand jury is to be conducted and who does it, and the timing of a material witness in a indicted offense.
So I understand that framing, Your Honor, but it begs about 7 questions. Was the grand jury misused? I mean, the statute says you're allowed to take a witness to a grand jury. The statute says you're allowed to present to the grand jury evidence of a new crime. The grand jury's secret. All of these things are baked in the cake. So without any evidence of some sort of egregious misuse of the grand jury, I don't know how you could even say the fact that a grand jury was used as opposed to a deposition or something else. It tells you nothing about what happened in this case, other than that's what happened in this case. And even if you make a due process claim, at some point it has to affect trial. And so I'm trying to work with you here and get to the idea that it's not necessarily false testimony, it's that the
We covered the false testimony, we thought,
right, so it's not
in the
that,
last one.
so it's if it's not false, we don't have a problem. It's just good aggressive cross-examination of a witness. If it turns out to be false, and
Well, that's the cell phone data evidence.
right, and that's
That's
the
what-
basis, and that's the basis of the cross-examination of this witness. This is what made him nervous, because again, if you're a witness who has lied to the grand jury, and the state says we have proof, let's take a different example. You said you're in Ohio. We have gas station video that says you were in Gatesville. I would recommend you not take a stand and say you're in Ohio. He's been threatened with perjury. Aggravated perjury if it's a material issue. The fact that that witness is afraid because if he testifies untruthfully, he's going to get caught with perjury. All witnesses should be afraid of that. There's nothing wrong with that. And so the propriety of warning, threatening, we don't know the tenor of it because we have affidavits that didn't need to be believed by Judge Johnson. But however, Robert Moody conveyed that information to a represented witness. None of that matters if Moody had the goods. And we still don't know that. So in terms of him making a bad faith threat or warning, we can't determine that for the same reason the appellant couldn't win the last time. If it was reckless because the record doesn't show that we sat down and did all the math and figured out not only these times accurate, it's 5 versus a 6-hour shift, but that we know that we're not having a problem with the cell towers and the location of where the roommate was that night. We don't know. We still don't know. But if further development of the record could show that, gosh, even though Moody said, well, we had our investigator who knows this stuff, he looked at it and he said, this is all true, and the map's on the back. He said that as an officer of the court. If that wasn't true, or if our investigator did a really bad job and should have known it, then you're in the world of reckless confidence in unadmitted impeachment material. I don't know of anything like it. Maybe such a claim could exist, but again, there just needs to be a lot more factual development of that point. Again, I am not saying that there aren't a lot of questions about what happened on the record. And then you can pick through any record and you can look at objections that should have been made or strategies that were employed that shouldn't have been or should have been. All I can tell you is that the claims that are raised, we're at the point now where the record just doesn't permit relief on.
Let me ask you. If the court respectfully disagrees with you and decides that due process was violated and he did not receive a fair trial, at this point, just stay with my hypothetical. On the one hand, we reverse, let's say we really don't know what the CCA is going to do. Let's just set that over here for the moment. If a reversal were to stand based on due process and fair trial considerations, on the one hand, I still believe that the grand jury in this country is to be treated as small s sacred. That being said, this is an unusual case. You just stated that as well. How deep, if it were reversed and retried, could the parties go into the grand jury proceedings? I'm not talking about just the subpoenas and everything else, but there are some instances where you can actually reach in, raise the curtain, and get into some of the Q&A and presentation in front of the grand jury. I really wish I was not even thinking about this, to tell you the truth.
Me too.
But thank you. But the fact is, I want you to talk me out of it if you can.
First off, I can't promise you that a retrial could be had. There's time, we have, these sorts of cases are what they are. So it's not a foregone conclusion. I think the fact that what happened in the grand jury didn't come up in this case, I think fixes your problem. If it would have been more interesting had the roommate caved to all the illicit pressure that was being applied to him, and he decided to testify consistently with what the state says the phone records showed, and inconsistently with grand jury. This would have presented an interesting opportunity for defense counsel to say, I would like to impeach him with his grand jury testimony. He's my witness, but I'm allowed to impeach him. So I'm having a hard time coming up with a factual scenario where one would want to pierce the veil of that proceeding in this context.
Fair enough.
I think, though, a lot of the conversation we're having, I don't want to use the word dangerous, because it isn't, but it raises issues. The idea that we're going to complain that, well, this was a secret proceeding. Well, yeah, it's secret. It's secret for a good reason. It's one thing, if you're saying it shouldn't be secret because all we were trying to do is lock in a witness's testimony, and for good reason, I would add. Again, the state doesn't explain why the initial grand jury subpoena was given. But it's not hard to imagine if you look at the testimony of the roommate, appellant's friend, he waits 6 weeks after his roommate is accused of rape to come forward and say, oh yeah, I was home and I didn't hear anything. This is why the state from get-go said, we don't believe him, we're not interested in this, but we want to talk to him. So I don't know how much more is involved between that and we need to get him in the grand jury. But we do know that the office's investigator had made an appointment and the roommate had agreed to show up and then didn't. And then the next piece of information we have is, well, we're being told that the defendant and maybe his lawyer were saying, don't cooperate and don't show up to anything. People do that. I'm sure some witnesses have said that before, and it is their right. However, there was something about this that told the prosecutor in this case, I would really like to have him sit down. This sounds more like tampering than it does somebody who just doesn't want to get dragged into it more than he needs to. And frankly, when you read the record and you see that there was a lot of official involvement from people beyond the defendant and counsel, there were a lot of things going on. There were a lot of moving parts in this case. And to decide that the state did something improper by doing something the legislature tells them they can do on this record, that would be a giant problem. That would send a message to prosecutors that here's a tool that you're allowed to use and certainly not abuse, but the fact that it can be used this scantly, this rarely, and the one time that it does, it gets flipped for whatever reason, because this record doesn't develop it, I think that would do a lot of harm.
Thank you.
I know opposing counsel didn't talk about
Point four.
the other issue. I think that's been briefed pretty well. And I would just say that, it might appear curious why you'd object to the line of questioning when it's cross-examination of the defendant. And then not object when the witness comes in as a rebuttal. But frankly, it seems to me like an adjustment and a recalibration on the fly. Her testimony clearly didn't work. We're never here if it works. But the cross-examination of her, rather. However, she gave a lot of testimony that cast the defendant in a better light in terms of his, whatever violent nature he might have. And, a big part of the defense is that the physical injuries sustained by the victim were as a result of his large penis. And he took the stand and said that, and his ex-girlfriend under oath confirmed that. So, I mean, that's a useful piece of information that I think Mr. Sibley could have seen, let's go ahead and embrace this and turn it to our advantage. So, I think that's it. If there are no other questions from the court.
No, thank you.
All right, thank you.
Thank you, counsel.
Just very briefly,
I've been asked to have you at least touch on point four, what?
okay, point four is the testimony of the lady that
From Boise.
Alan from Morris. And again, the whole basis of that point was that when the defendant testified or Alan testified during trial, they asked him, have you ever hit a woman? Or I think the first thing was, do you respect women? That's the question. And then later they said, have you ever hit a woman? He said he did respect women and he never hit a woman. So in their mind, and this is the basis they used to be able to bring in the lady from Boise who he had dated and lived with for a time up there, to say that at one point there was a dispute about him, that he either struck her and kept her from leaving the apartment for a short time. But she went on and dispelled most of that. Again, our position on that is you're setting on an unrelated, irrelevant matter that didn't go to the consent for the sexual encounter that occurred and he was on trial for, to bring in someone to bring in just extraneous offenses, extraneous facts that really had no purpose except to smear the appellant. So that's basically what we said. Now, I believe that the non-objection to that, it's going to be more difficult to explain, to be honest with you. But that's the basis of that argument. It was created. It was kind of a straw man situation where they had already subpoenaed her from Boise and they were going to make sure that she got on by the examination of the appellant. And we don't believe that even sets up that as being admissible at that point. So that's the basis of that as brief as I can. The only thing very quickly, I think we're all intelligent people here, hopefully. And if a prosecutor says that a witness who's going to testify to events that occurred in the apartment where the appellant was on the evening in question, is going to testify to it, but yet is saying, well, I'm going to take the Fifth Amendment to that. And they say, well, it hasn't proven why, that was caused by the prosecution or by these records or anything else. I think we're not being logical about that at all. I mean, why would this Penny Taggy even have floated the idea of taking the Fifth Amendment unless it happened exactly as we said it would? And that they took him before a grand jury and threatened him with advised him that he would be prosecuted for 2 counts of aggravated perjury if he got on the stand, would he even consider taking the Fifth Amendment? That has been proven. If they say the record doesn't show that, I completely disagree with that. And as far as the harm, of creating, well, he testified anyway, and he withstood the cross-examination. While they're waiving records, if they're saying, says you're lying while you're up there, and we're gonna take the positions, we sit up here in an appellate court, that 12 people over there during the course of a trial don't pay any attention to that. Harm can be presumed. I mean, that, and it's done as if it could have an effect on the outcome of the verdict. And I think clearly in this situation, it could have an effect on the outcome of the verdict.
Now, how do you tie that to our considerations of Marion and the fact that we have to do the harm analysis? Well, you just said.
Because, again, I think that if in fact, I had it here, the Guardiola versus State, that was cited by a court of appeals in Houston, talking about an abuse of the grand jury. If a witness, everybody, both sides, the state, defense should have the ability and access to witnesses to subpoena them and have them appear. And if the state has the power to have a witness who's testifying that I didn't hear a scream in the apartment while I was there that night, was going to take the Fifth Amendment about that. That impacts his due process to have witnesses brought up, just like the state would. The defense doesn't have the ability to go to the grand jury, subpoena some witness, and threaten to try to file a aggravated perjury charge against them because of what they said there. Defense can't get to the grand jury. That's a very powerful tool. It's really for the protection of individuals so that people aren't charged and prosecuted on crimes that don't have any basis. But this time, and then there's just no question how it was used. It was used on a witness, and I think the telling statement by the assistant DA prosecuting this is, we don't need a continuance. He's not even going to testify. He's going to take the Fifth Amendment. That's in the record. Now, why was that said? If he says there's no evidence whatsoever of what we're arguing about right here. So if the court says, okay, well, and then the other thing is the statement that we're going to charge you with aggravated perjury for 2 counts when they aren't sure what the records show and they don't prove what the records show. Again, how would they do that? Why, if they knew those records show he was telling the truth, why would they tell him that he would be charged with 2 counts of aggravated perjury if he testified the same way? And so that's why, in my belief, we don't show those, don't say that. They're used just like they were. Makes no difference what they show because they used them against the defense witness who's about to get up there in the middle of trial with an assistant district attorney questioning him who's already told him he's going to be charged with 2 counts of aggravated perjury if he testifies the same way that he has before the grand jury in the courtroom here today. So that's the harm. I don't know how else to tell. Thank you.
Let me just say. Let me thank both of you. The reason you're arguing this again is for my benefit, since I wasn't here at your time, and I appreciate y'all coming. Thank you.
As y'all know, this court has struggled with this case. In 20+ years of me doing this, I've seen one criminal case resolved by an agreement subsequent to the Court of Criminal Appeals reversing it. I have no idea and don't want to know if there is anything of that nature that, I mean, because you're talking about, we are going to proceed. We're going to write an opinion in this case and dispose of this proceeding. What happens to it after that is up to y'all. But the case to which I allude was a case involving a fraternity house in Bryan College Station. And it was reversed by us CCA reversed us in that case. It went back to the Bryan College Station or Brazos County prosecution, and they worked out something. Don't know what they did, don't know how it was done. But in recognition of the fact, as the state has recognized that regardless of what happens in this direct appeal, there is I don't know whether you call it room for, probability of a writ case. I just encourage y'all to think outside the box. You obviously have a window of opportunity before our opinion issues, but you know, this is a thorny issue of the use and argument of abuse of the grand jury process. A lot of people's lives and time will be invested and state money spent one way or the other, and private money spent, that you may want to explore options. And with those comments, this case is submitted. Y'all are excused. If there's any post briefing to be had, I don't remember any cases being cited that were not previously cited in the briefs, but if there are, that would be due by Friday. Or if a motion was filed, it could be extended. But with that, thank y'all for your arguments. We do appreciate the fact that you had to come 3 times for argument, but at the same time, we had to sit through 3 of them too. So, but we thank you very much. Thank you, council. Y'all have a good day.
Thank you.